I get a lot of different questions related to privacy and estate planning. So today I'm going to talk about different issues related to privacy and one's estate plan. So let's get into it. All right, so how does privacy impact one's estate plan? So there's a few different things that I can talk about here. First one is related to probate. So just a quick reminder, if an individual passes away and they have assets in their individual name, those assets have to go through probate. Regardless if one has a will or doesn't have a will, their assets have to be probated. That's how assets go from that person who passed away to the next generation or to heirs, whoever that person left it to, or if they didn't have a will, whoever the state is going to decide those assets go to. So that process, the probate process, is a very public process. Anyone can access the information that goes through the court system. So think about creditors, the type of assets that you have, the value of those assets, who's going to actually benefit from them. All of that goes through the probate process. And if there's holdups because there's disagreements among family or others, then all of that that's going to be part of the probate process is going to be subject to public display as well. And so a lot of times people don't want that to go through probate process because they don't want people to be able to access information. Maybe they live in a small community, maybe they're famous, maybe they just have nosy family members or a nosy community, so they want to avoid that. The way to do that, as a quick reminder, is through trust planning. Typically, a revocable living trust is used to avoid probate. An irrevocable trust can be used as well, but those usually are implemented for different reasons other than just avoiding probate. Okay, so that's one issue related to privacy. Another issue is a lot of times people are interested in privacy related to real estate and land transactions, and they think that a revocable living trust is going to be able to offer them probate. Short answer is no, it doesn't. Some people are interested in what's called a land trust, and not every state technically owns a land trust. But essentially what it is a revocable trust that names someone other than you as the trustee, and that person's name is going to be associated with the trust for purposes of real estate transactions. But the problem there is you have to give up trusteeship to someone else, and you have to trust them enough to be able to transact the way that you would want them to transact. So it does help, though. There is a level of privacy, more so than having assets in your individual name. So if I would suggest that you not give your revocable living trust a name associated with you or your family. Sometimes an attorney will just name a revocable trust. The client's name is John Smith. They'll name it the John Smith Revocable Trust or something like that. Or so I say avoid that. Go in a different direction. Give it something that's more discreet. Also, if you are the trustee, and this is what I was getting to a second ago, then you will transact in your individual name on behalf of the trust. But people don't always know who the trustee is, who the beneficiaries of that trust are. Even if you are the trustee, that doesn't mean you're the beneficiary. So I would leave the name revocable out so people don't know if it's a revocable trust. So I think there's some different measures you can cook in there to make sure that you're maximizing privacy. And then also kind of two related last items here are, what happens if you do get sued? Well, quick reminder, a revocable living trust doesn't have asset protection. An irrevocable trust does. So again, good practice is not to name the trust in a way that ties something back to you. But some other issues related to that, in most states, any of the details related to that trust that come out in some type of litigation, if it gets sued, are going to be part of the court proceedings, and it's going to be subject to public domain. There are some states that say that there's a seal on those details related to the trust and not going to be subject to public domain. So South Dakota has the strongest laws around that. It's a perpetual seal. And it's indefinite, so it lasts forever. And it's automatic, so it happens immediately and it lasts forever. Other states they leave it to the judge's discretion, and then also the seal may only last 2-3 years. But most states have nothing around this. So someone who may be prone to being sued, it might make sense to have your trust done in different jurisdictions that have strong laws around this. And then lastly is what's called quiet trust laws. So in most states, when a person hits a certain age, 18, 21, just depends, the law states that that beneficiary, once they hit the age of majority, they are due the details of the trust. So they're allowed to know what the trust says, how it benefits them. But some states, again, South Dakota, says that you can actually completely eliminate the ability of the beneficiary to access information related to the trust. So there's actual law that provides for you to do that. So there's a few different things around there. So when it comes to privacy, think about probate. You can avoid that, avoid public domain. Two, land transactions are a big thing. So your revocable living trust or irrevocable, make sure that it doesn't have a name that ties back to you. Three, this idea of a perpetual seal related to information and related to the trust that may come out in a court proceeding. And then four, quiet trust laws, making sure that beneficiaries cannot access information. So privacy comes in a few different ways in the estate planning realm. So make sure that you're considering all of those and looking at the laws of your particular jurisdiction and figuring out if it makes sense to look at a different jurisdiction like South Dakota.